Hello viewers, welcome to my channel. I'm Hasham. So now in this video I'm going to solve the practical problems on Sale of Goods Act 1930. In examination you may be asked a theory question in this business law. Apart from that, one case will be given. So you have to apply the provisions of the act and solve the case, decide the case. So this video is exclusively on the cases regarding the provisions of Sale of Goods Act. Already last 4 videos I have prepared on Sale of Goods Act 1930. I have explained you the meaning of the term sale, what is contract of sale, what are the essentials of valid sale, what are the differences between sales and agreement to sell, what are goods and what are the different types of goods, then what are conditions and warranties, differences between conditions, warranties, implied conditions and implied warranties, caveat emptor, let the buyer beware, and what are the exceptions to this caveat emptor doctrine, and lastly unpaid seller and what are the rights of unpaid seller. All these things I have explained in detail in the last 4 videos. This is the last video on Sale of Goods Act regarding the cases. So if you have not watched the earlier videos, it will be difficult for you to understand the case laws. So I suggest you, before watching this video, go through, watch the earlier videos, 4 videos in which complete provisions I have explained on Sale of Goods Act. Go to the playlist of my channel, select the subject business law, select the videos of Sale of Goods Act 1930. Watch the first 4 videos, definitely you will get a command on all the provisions. You can understand these problems. So before starting the problem, I expect my viewers to have a printout of the problems. 25 cases, 25 problems I have made, and these are provided in the link under my description. So before watching this video, take a printout of all the problems, keep it ready, and you can be able to understand the problems. First problem I am reading out, see carefully. Anmol purchases some chocolates from a shop. One of the chocolate contains a poisonous matter. Here buyer is Anmol. Anmol has purchased some chocolates from the shop, and one of the chocolate contains poisonous matter, and as a result Anmol's wife has eaten it, falls seriously ill. What remedy is available to Anmol against the shopkeeper? Here Anmol, the buyer, has purchased chocolate from the shop, and ultimately the chocolate contains some poisonous matter, due to which Anmol's wife was seriously ill. Now what action Anmol can take against the shopkeeper? Previous videos I have explained you about implied conditions and implied warranties. One of the implied condition is the goods supplied by the seller must be of merchantable quality, and if the goods are of consumable, that means eatable items are there, then it should not only be merchantable, it should also be wholesome. That means suitable for consumption by the human being. So apart from merchantability, the goods should be wholesome because it is consumable. Chocolates are consumable. Here the goods are not merchantable. The goods are not wholesome because poisonous matter is there. What is the action Anmol can take? Anmol can repudiate the contract and claim damages from the shopkeeper. Anmol is having 2 rights. He can repudiate the contract, cancel the contract, and also Anmol can claim damages from the shopkeeper because there is a breach of implied condition. Condition as to merchantability and condition as to wholesomeness. So this is the answer for this problem. Hope you understood. Now second problem I am explaining. Ashok sells a horse to Bharat. Remember, listen the problem carefully. Understanding the problem is half solved, because this type of problems will be asked in examination. So if you watch with full concentration, it will be in your minds. In examination you can easily write the correct answer for this type of cases. Second case, second problem. Ashok sells a horse to Bharat. When Bharat goes with the horse, he is arrested by the police on the charge of keeping stolen property, as the horse belongs to Chetan. Actually the real owner of the horse was Chetan, but Here Ashok sold the horse to Bharat. That means Ashok is not having the ownership. Actually the ownership is with the Chetan. But Ashok is non-owner. He is not the real owner. But he sold the goods to Bharat. That means Bharat will not get the good title. Ashok itself does not have the title. How he can be able to sell the horse? So that means Bharat got a defective title of goods. Now, can Bharat sue Ashok? And if so, on what basis? And what damages he can recover? Ultimate question it is asking you, can Ashok recover the amount paid to Bharat? Can Bharat sue Ashok? Because Bharat has purchased, sold by Ashok. So can Bharat recover the amount from Ashok? Because ultimately Chetan will take away his horse. The real owner of the horse is Chetan. So Chetan will take the horse. But Bharat has already paid the amount to Ashok. Now what is the right? This is the breach of implied condition as to title. Implied condition as to title. So here it is assumed in a contract of sale that the owner is having the title. When in reality owner is not having the title, he cannot sell the goods. So here Ashok does not have the title, but Ashok has sold the horse to Bharat. That means Bharat can be able to recover the amount along with the damages. Recover the amount along with damages from Ashok. So here there is a breach of condition as to the title of goods. I told you, title of goods. So Bharat can consider the contract as repudiated and recover the damages from Ashok. That's all. Now third case. See the case number 3. Abdul purchases a typewriter from Hassan. Abdul is the buyer. Seller is Hassan. A typewriter is the subject matter of the contract. Then Hassan's plea that it is old, it is in excellent condition. He is describing, the seller Hassan is describing that the typewriter is old, but it is working perfectly. It is in good condition. Abdul finds later that the typewriter was not working at all. Can he reject the typewriter and recover his money? Yes, of course. When the goods are sold by description, that means the goods should correspond with the description. When Hassan is selling the goods to Abdul, he is claiming that the typewriter is old but it is in working condition. There is a description he is giving. But ultimately the buyer, Abdul, is finding that the typewriter is not working. That means goods are not according to the description. So there is a breach of implied condition as to description. Implied condition as to description. Actual goods and the described goods are not same. Actual description is the typewriter is very good, but in reality the typewriter is not working at all. So what buyer can do? The buyer Abdul can repudiate the contract, can reject the typewriter and claim the money from Hassan. So goods should correspond. Whenever goods are sold by description, the goods should correspond with the description. If the goods are not corresponding with the description, the buyer can repudiate the contract, reject the contract and return back to the seller and get back his money. Now next, fourth case. Taqi sends certain goods to Ahmad on approval. There's a method of selling of goods where the goods will be sent on approval basis. That means the seller will give the goods, consign the goods to the buyer and will tell him that you, first of all you check, you use the goods. If it is satisfied, you keep it. Otherwise, you return it. It is called sale on approval basis. So here Taqi sends certain goods to Ahmad on approval. Ahmad does not return them or ask seller to take away after 8 months. That means the buyer, Ahmad, has kept the goods for 8 months. Till 8 months he has not returned. He has not returned the goods to Taqi, seller. Now is Ahmad bound to pay for the goods? Yes, of course. According to the provisions of Sale of Goods Act, the goods should be returned within a reasonable period of time. When goods are sent on approval basis, the goods should be returned within a reasonable period of time. Here 8 months is not a reasonable period. It's a huge period, more than reasonable period. The buyer, Ahmed, has taken more than reasonable period. 8 months he has taken. That means till that time the seller cannot wait. So in that case, it will be assumed that buyer Ahmed has purchased the goods. Now Ahmed is bound to pay the price. Now he cannot repudiate the contract. Next, fifth case. Certain articles of furniture were delivered. Remember, certain articles of furniture were delivered by a dealer to Bahadur on sale or return within a week. So a furniture maker has given some furniture to Bahadur, one customer, on sale or return basis. That means if you want to purchase, you keep it. Otherwise, if you don't want it, return it back to the supplier, seller. That is called sale or return basis. But within 1 week, the time is specified by the supplier. The supplier says, if you don't want to keep the goods, if you don't want to purchase the goods, return the goods within 1 week. Within 1 week. 3 days after, 2 of the Bahadur's creditors, in execution of a decree, seized the articles. The dealer claims his goods. Decide. Bahadur have to pay some amount to the creditors. He is owing some amount to the creditors. Now creditors got a decree from the court of law, and 2 of the creditors have seized the furniture in the possession of Bahadur. Bahadur is having some furniture which is given by the supplier, which is given by the shopkeeper on sale or return basis. He has to return the furniture within 1 week if he does not want to purchase. But only 3 days after, the creditors of Bahadur have seized the furniture. Now dealer is claiming that it is my furniture. Dealer is telling to the creditors that this furniture does not belong to Bahadur. It is our furniture. We want to take it back. But creditor says amount is due from Bahadur, so I am taking his furniture. Now decide. Now we have to see whether ownership has been transferred to Bahadur or not. No. The supplier has given 1 week's time to Bahadur. No, 1 week was not completed. Within 3 days, the creditors have come and seized the furniture. That means the ownership is not transferred to Bahadur. The ownership of the furniture is in the hands of the shopkeeper. The shopkeeper is the owner. That means the creditors cannot take the furniture because the furniture owner is not Bahadur. Furniture ownership is of the shopkeeper. So in this case, the dealer is justified. The furniture should be handed over to the dealer. Because there is an implied condition that only owner can sell the goods. The title should be at the seller. Here the seller is the shopkeeper. So in this case, the dealer are justified. They can take the goods from the creditors. Next, sixth point. R purchased a second-hand motor car from D. R purchased a second-hand motor car from D and used for 4 months. Subsequently, the car was seized by the police as the car was stolen one. R sued D to recover the price which he have already paid. Can R recover the money from D? Yes, of course. D does not have the title. There is a breach of condition of title. Implied condition of title. D does not have the ownership. It's a stolen property. It is a stolen property. But without disclosing that, D has sold the goods to R. That means when D himself does not have the ownership, how he can give the ownership to R? When there is defective ownership in the hands of D, defective ownership will go to R. R is not the owner. That means the police will seize the car and give it to the real owner. Now what action R can take against D? R can sue D for the price paid. R can sue D. R has already paid the amount to D. So D should return back the amount to R. That's all. That means there is a violation. There is a breach of condition of title. Breach of implied condition of title. That means the seller D does not have the title ownership. Next, seventh one. A asked a bus dealer to provide him a bus which is appropriate for touring purposes. So A is a customer. He approaches a bus dealer and asks the bus dealer to give a bus which will be suitable for touring purpose. A recommended, supplier is A. A recommended you purchase deluxe bus. So therefore A has purchased deluxe bus but did not find convenient for the touring purpose. After purchasing the bus, A found that this bus is not suitable for touring purpose. Can A repudiate the contract? Yes, of course. According to the provisions of the Sale of Goods Act, when the buyer has explained the purpose of the goods, when the buyer has explained the purpose of the goods to the seller, it is the responsibility of the seller. It is the obligation of the seller to give only that goods which is suitable for the purpose. Here, Mr. A approached to the bus dealer and asked to give a bus which is suitable for touring. But the bus is not suitable for touring. Not suitable for touring. So A is having the right to repudiate the contract and return back the bus to the supplier, dealer, and take back his money. Take back his money. So here A can repudiate the contract. When the buyer informs the purpose to the seller, then it is the obligation of the seller to supply only that goods which will fit the purpose of the buyer. Now, if it is an implied condition of the part of the seller to sell the goods according to the purpose of the buyer. That's it. Now, eighth problem, you see carefully. A asked a chemist to recommend a medicine which can cure headache. So A goes to a medical shop, chemist, and asks the chemist to give a tablet, a medicine which will cure headache. So chemist suggested one medicine and told it will cure not only headache but also it will reduce your fever also. But A did not find that medicine curing the fever. After consuming the medicine, A found that it is not cure for fever. Fever is not dropping. Then can A repudiate the contract or can he claim damages? He cannot repudiate the contract. He can claim only damages. So only there is an implied breach of implied warranty. There is no breach of condition. It's a breach of warranty. So A can claim only damages from the chemist. Next, ninth problem. X bought a bottle of wine. While opening its cork in the normal manner, the bottle broke off and injured X's hand. Can X claim damages from the seller? Yes, of course. Of course. The goods supplied by the seller should be of merchantable quality. It should be merchantable quality. Here in this case, X has purchased a bottle of wine. While opening the cork of the bottle in the normal manner, suddenly the bottle broke down and injured X's hand. Now, X will sue the shopkeeper for damages. So, yes, X can claim damages from the seller as the bottle was not of merchantable quality, due to which X was injured. The bottle is not of merchantable quality, not standard quality. Next, 10th problem. A person purchased certain hay stock, that is dry grass. Hay stock means dry grass, which was lying on the ground of the seller. It was destroyed by fire before taken delivery. Before taken the delivery, it was caught fire. Decide who should bear the loss. Again I repeat, a person purchased certain hay stock, that is dry grass, which was lying on the ground of the seller. It was destroyed by fire before being taken delivery. Decide who should bear the loss. The loss should be borne by the buyer. because it was in a deliverable condition at the time of making the contract. The buyer should bear the loss because the grass was in a deliverable condition at the time of the accident. So when fire broke out, it was in a deliverable condition. That means it can be taken away by the buyer. He has not taken. So the loss should be borne by the buyer. Next, 11th one. M purchased a second-hand typewriter from B for rupees 1000. M purchased, buyer, from B, seller, 1000 rupees typewriter and spent 200 rupees on having it overhauled. It's a second-hand typewriter. So after purchasing the typewriter, M has spent 200 rupees on overhauling. Unknown to both the parties, the typewriter was a stolen property and M has to return to the owner. Actually, B was not having the ownership. It's a stolen property. That means B does not have the ownership title and B has sold to M. That means M also will not have any ownership. So M has to return the typewriter to the real owner. Now M has to sue B. Who is the seller? B. For getting not only the amount of rupees 1000 but also the amount spent on repairs 200. The 1200 rupees should be claimed from the seller B. From the seller B. 11th point problems completed. Now see the 12th one. A purchased milk from B. A is the buyer. He purchased milk from B. After consuming it, A falls sick. Can A claim damages? Yes, of course. Already we have seen. The goods sold should be of mercantile quality, and if the goods are foodstuff items, it should be wholesome. There's an implied condition that the foodstuffs should be of wholesome quality. That means suitable for consumption by human being. Milk is a food item, so it should be wholesome. Here milk is not wholesome. After consuming it, he falls sick. That means the buyer can sue the seller for damages. Next, 13th. A purchased a tomato sauce bottle from B. While opening the bottle, the cork broke and A was injured. Can he claim damages? Yes, of course. When the buyer is opening the cork of the bottle of the tomato sauce, the bottle broken, then the buyer was injured. He can claim damages from the seller because the goods supplied are not of mercantile quality. It is the implied condition that the seller must supply only mercantile quality that should not injure the buyer. Here, the buyer can claim damages from supplier. Then 14th one. A TV set was sold to an illiterate. The set was defective. In spite of repairs, it did not work. Explain the remedy available to the buyer. So TV set was sold to an illiterate person. It was defective. It was defective means it is not of a perfect quality. It is not of a mercantile quality. There is an implied condition that the seller should sell only mercantile quality goods that should serve the purpose why the buyer is buying. Here television set is purchased so that he can be able to watch the TV. Here the TV is not working. That means there is a breach of mercantile condition. So the buyer can repudiate the contract and return the TV set to the seller and claim his money. Then 15th one. A buyer purchased a radio, but it was not working from the date of purchase. What are the rights of the buyer? When the buyer has purchased a radio, it should function, it should work. From the day when the radio is not working, that means the quality, it is not a mercantile quality. So the buyer has the right to return, to repudiate the contract and return the goods to the seller because it is not working. There is a breach of implied condition as to mercantile quality. The seller has to bear the loss. So totally 15 problems I have explained you. Come on, now see the 16th problem. 16th one. A asked for old oats when he went to a shop. A is a customer. He goes to a shop and asks the shopkeeper to give old oats. He depended on what the shopkeeper said. The shopkeeper sold old rice as old oats. So actually customer wants old oats, but the shopkeeper has given him the old rice. A bought them. Later he realized that they are old rice. Has he got the right to return them? After coming home, the customer A found that it is not all old oats, it is the old rice. But he asked the shopkeeper to give old oats. So the buyer has the right to return, repudiate the contract, return the goods back to the seller, because when the customer has said the purpose or customer has described what he wants, that means seller has to give that only. A person is asking peas and he is given beans. How he can be able to accept it? So there is an implied condition. There is an implied condition that the seller must sell only that goods which are required by the buyer. Here buyer wants old oats. The seller has given old rice. So that means the buyer will have full right to return back the goods to the shopkeeper and get back their money. Next, 17th problem. A purchased a car from B. So B is the seller, A is the buyer. After using it for 3 months, X, the real owner, claims it from A. What is the remedy available to A? Actually, A purchased the car from B. After using the car for 3 months, the real owner of the car, Mr. X has seized the car, taken the car from A because he is the owner. That means the seller B is not the real owner. He does not have the ownership. He does not have the ownership and he has sold the car to Mr. A. That means when B himself, he does not have the ownership, how he can give the ownership to A? A will not become the owner. The real owner will take the goods and A will have the right to get back his money from the seller. The seller is B. So A will sue B to recover the amount paid for the car. Next, 18th. A person suffering from a headache approached a medical shopkeeper and completely relied on him in taking a suitable tablet for headache. So a customer goes to a medical shop and asks, I'm having headache, so give me a tablet. So already purpose have been told by the buyer to the seller that I need a tablet for my headache. Even after taking the tablet, the headache was not cured. Then can the person claim damages from the shopkeeper? Yes, of course. The person can claim, because when the buyer has described what he wants, what type of goods he wants, it is the responsibility of the seller to give that goods only. If the seller has given a different goods, then the buyer will have the right to claim damages. So in this case, the buyer of the tablet will sue the chemist, will sue the shopkeeper for damages from him. Next, 19th one. X bought some milk from Y. The milk contained some poisonous germs. X's wife took the milk and got infected, as a result of which she died. Is X entitled for any damages? Yes. In case of foodstuffs and consumable items, there is an implied condition that the seller must sell only those goods which are mercantile quality, and also it should be wholesome. It should not be dangerous to the health of the buyer. Here, the Mr. X has bought the milk which contains poisonous chemicals, and due to which the wife of X died. Now the X can sue. X can sue the seller for getting the damages. Because there is a breach of condition. There is a breach of condition regarding the wholesomeness. Next, 20th. Problem number 20. Shahrukh purchased a color television from Onida company. Shahrukh purchased a color television from Onida company and paid the price. But before it is packed by the seller, its screen was broken due to a stone thrown by a miscreant. Who should bear the loss and why? So Shahrukh goes to an electronic shop. He purchased color Onida television, but before the television, he has paid the price. But the television was not packed, not separated. So before being delivered, before being packed, due to a miscreant, one stone came and the screen was smashed, broken. Now who should bear the loss of this television? Buyer or seller? Here in this case, the goods are not delivered, not packed. Still the goods are in the custody of the seller, Onida company. So ultimately the loss should be borne by Onida company because it is not packed. Once it is packed and delivered to the buyer, then the responsibility goes to the buyer. Here it is not packed, not delivered, still in the custody of the seller. So seller will bear the loss. Who is the seller? Onida company. Next, 21st. B goes to a shop to buy a pattu sari, a type of sari, pattu sari, thinking that it is a kanchi sari. It turns out to be a cotton sari. Can he return the sari? If so, under what ground? So actually customer B goes to the shop to buy a pattu sari, thinking that, so she has bought a pattu sari thinking that it is a kanchi sari. What the customer think that it is a kanchi sari? She assumed. But after coming home, she found that she has purchased a wrong sari, that is cotton sari, that is not a kanchi sari. Now can she return back the goods to the seller? Can he sue the seller? No. Here in this case, she has not described anything to the seller. She has taken her own decision. So she had committed a mistake. Actually, she wants to purchase a kanchi sari, but by mistake she has purchased a cotton sari. Now, here the doctrine of caveat emptor will apply. Caveat emptor. Let the buyer beware. When a buyer goes to buy something, he should be aware what he is buying. What he is buying. So there is an implied condition that the buyer knows which are the goods which will fit for this purpose. So in this case, she does not have any right to repudiate the contract or claim damages. She has to bear the loss. She has to suffer according to his wrong decision taken. So B cannot return the sari because the doctrine of caveat emptor applies. As per the caveat emptor, the buyer should be aware regarding the quality and fitness of the goods. Now 22nd problem. A finds a car and after reasonable efforts to discover the owner, sells it to B. A finds a car and after finding the car, A searches who is the owner of the car. But unfortunately, he was unable to find out the real owner of the car. Owner was not found. Then what A has done? A has sold the car to B. Sold to B, who buys without knowledge that A was merely a finder. The buyer does not have the knowledge that the seller does not have the title. He has purchased the car. Can the true owner recover the car from B? Yes, of course. The true owner of the car can recover the car from B. B does not have the title. When A does not have the title, then B also does not have the title. Real owner will take his car. Now B can claim the amount paid from A. Now B, the buyer, he can claim the amount which is paid to A. Next, 23rd. X sells goods to Y. Y becomes insolvent while the goods are in transit. Can X stop the goods in transit? Last video I have explained you about unpaid seller. Unpaid seller. What are the rights of unpaid seller? When the goods are dispatched, when the goods are in transit, but the seller is unpaid and the buyer has become insolvent. When the seller got the information that the buyer has become insolvent and the seller is unpaid seller, then the unpaid seller will have the right for stoppage of goods in the transit. The seller can order that the goods should be stopped in transit and returned back to the seller. The goods should not be delivered to the buyer because buyer has become insolvent. Next, 24. A contract was created to buy certain goods to be imported from Singapore. The goods are to be imported from Singapore. The purchasing party paid the total amount in advance. Mr. X, suppose Mr. X entered into a contract with a buyer that my goods are coming from Singapore, it is on the way in transit. After receiving the goods, I will deliver the goods to you. There is a contract between the buyer and the seller, and the buyer has paid the advance money also to the seller. The stock damaged due to seawater and lost merchantability. While coming, due to seawater, the goods were damaged, and it is damaged in such a way it has become unmerchantable. It lost the merchantability. Then can buying party claim his advance back? Yes, of course. If the goods is not merchantable quality, after reaching the port, after arriving the goods, it is found that the goods are not of merchantable quality. That means buyer will not take the goods because it is unmerchantable. The buyer will have the right to get back the advance money paid to the seller. Next, 25th, last problem. There was a sale of 25 tons of paper to be shipped in November. There is a contract between the buyer and the seller that the buyer will buy 25 tons of paper to be shipped in November. So agreement is the buyer wants to buy 25 tons of paper in the month of November. The seller shipped 20 tons in November and 5 tons in December. So actually the agreement was made for 25 tons, but the seller has shipped 20 tons only in November and 5 tons in December. Can the buyer reject the whole 25 tons? Yes, of course. According to the provisions of the Sale of Goods Act, when there is an agreement between the buyer and the seller for a certain quantity, and if the seller has supplied lesser quantity, then the buyer will have the right to reject the whole lot. In this case, there is an agreement to supply 25 tons of paper in the month of November, but the supplier has supplied only 20 tons in November and 5 tons in December. Now the buyer will have the right. The buyer can reject the whole 25 tons back to the buyer, back to the seller. That is the right with the buyer. That's all. So 25 problems I have explained in detail regarding the sale of goods. So after watching, after listening these 25 problems, now you will be in a position to write in examination when a case will be asked along with theory question. Just like a theory question will be asked regarding explain the differences between warranties and conditions and warranties. And after that a case law will be given. The case law just now I have explained you. So before watching this video, you must take a printout of what the problems, what I told here, what I explained here, that is there in the link. Take the problem, watch the video, note down the points, you will be perfect regarding the case laws on Sale of Goods Act. So this is the end of the topic Sale of Goods Act. Inshallah, next video I'll make on the next topic under the subject of business law. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more viewers can watch the video and enhance the knowledge. Give your comments on these videos. And very pity to say, almost 50% of subscribers have not subscribed. They are watching, they are viewing the videos, they are satisfied, but still they are hesitant in subscribing. It gives more encouragement. If subscribers increases, it gives more encouragement so that more and more videos I can be able to make, which will be beneficial to the student community. So don't hesitate to press the subscribe button. Subscribe it if you have not yet subscribed. Inshallah, we'll continue in the next video.